presentation. Oh, are we good?
Yeah, we're good.
Okay. That you can use in the future. And if I provided you some helpful information in that regard, then I think I've set out what I hope to set out. So things are very different nowadays than they were when I first started practicing, just in terms of, things now are at the click of the fingertips, if in terms of research, legal research, if you're trying to find supporting material through the internet. I mean, when I started, we had to use typewriters and we had to use the Canadian abridgment for research. So I'm sure many of you probably never even heard of the Canadian abridgments, but all to say that things are a lot easier nowadays than they were, back in the dinosaur era when I started. A few little suggestions to start. I think it's really important that lawyers are on listservs, whether it's the Criminal Lawyers Association listserv, the WiCCD listserv, your local Defense Bar Association. And the reason for that is there's a lot of emails that you see where people send in cases that they've been successful on, or they ask a question about a legal issue and then they get some really helpful advice in response. And that's a good resource to have, and it's free when you're a member, and it's a great way of getting some knowledge. The CPD programs are also very valuable as well. Now, I know some of them can be more costly than others, but anytime you can watch a free one, or if you can watch a Law Society CPD program, if it's sometimes the local bar associations can get a group rate, that's always very important. They always have excellent speakers. And I've always been of the view that, you can never know enough, and, we're always able to learn something new. And the Law Society as well, if you go to their website and their webpage, they have a whole section, and it's not easy to navigate that website, mind you. But if you go to the practice supports and resources section, and then you click on legal research, and it'll take you to CPD articles, and you can click on access CLE, and you'll get program papers from all areas of law. And these are from conferences that they've had over the years, and they're include 2022 in terms of areas, and obviously of most interest to us is criminal law, but it also includes Indigenous persons and practice management. So I encourage, if you're not able to watch one of these Law Society CPD programs, or you weren't able to register for it, then you can easily access the papers that were presented through the Law Society website. So if someone's looking for extra reading on the side, you can get it from there. So my focus today, we only have an hour, and I want to try and give you some helpful tips and tricks when you're in the pretrial process, and if you're endeavoring to get the charges withdrawn, which I always see as the best possible result for the client, or resolved in terms of there's a plea of guilty, but it's obviously the best sentence that you can get for that client. Now, in terms of the other component of the pretrial process, there are cases where they're just not going to resolve, and they're going to have to proceed for trial. And I'm not going to get into issues on that side in terms of admissions and applications, time estimates, agreed statement of facts. I think that's probably a whole other presentation that we could do, especially when you consider all the applications that are involved in some of these cases, whether it's sexual assault type cases, or whether it's charter issues. So I'm going to focus more, just because of the time that we have, in terms of you're trying to get the charges withdrawn. So my approach to every case is the same, whether it's a big complex case that is boxes and boxes and boxes, or whether it's a small case and it's just a little file folder. And it's important to note that for every client, that case is very important to them. And I think without a doubt, being criminally charged is probably one of the most stressful experiences that somebody can encounter in their life, especially if there's media attention on their being charged, because then it's not only impacting them and their standing and reputation in the community, but it will impact their family as well. And now with social media being what it is, you will have a lot of people that will post negative comments online, and that can also be impactful if somebody has children. So, you know, things are very different nowadays than they were in the past. And I think it's important to keep in mind that, you know, at the end of the day, we are a service industry and we're a service profession. And, you know, it's always important to provide the client with the utmost of professional service to try and get them through the process. And I always regard it as being a privilege to represent somebody. And, you know, I aim and strive to provide every client with the best possible service that I can. And one thing that I've learned through the years, and that's probably the most common complaint when clients change lawyers, is that they were never kept informed by their former counsel. And I think it's really important that you always keep your clients updated in terms of every stage of the process, report back to them in terms of what is happening at the various stages. Make sure that you review the disclosure, the disclosure with them, and you get their input on it. You know, follow up with them if you need information from them. If clients call you, I have always made it a rule of my practice to return their calls within 24 hours. And if clients nowadays, many clients just email because it's easier, and it's the same rule, email them within 24 hours. And, you know, with the advent of the email, it's you know, a lot easier to get back to clients than if you had to, you know, send letters to them in terms of updating them. And I think that if you keep that in mind, that it will go a long way in terms of your client's expectations of the process and of your representation. So the first meeting with the client, and I know that this was some of these areas I'm going to cover, I know were touched on by Allison last week, but the first meeting with the client is to me, it's very, very important. And I spend probably 2 to 3 hours with a client for a first meeting, depending on what they are charged with. So they tend to be very lengthy, but you know, clients are always nervous and they're stressed given what they're dealing with. And I always also say, you know, never keep a client waiting. If their appointment's at 3 o'clock, make sure that you're there to get them, you know, at 3 or before to meet with you. Because, you know, I know how I feel when I'm kept waiting. So, you know, all it's going to do is just stress your client more. And it's, you know, it shows a lack of regard for their time. So it's certainly not a very good way to start the relationship. But I find that the best way to approach the interview is you start with obviously the most basic details, date of birth, address, contact information. And then I get as much background information and information regarding their personal circumstances that I can. And the reason for that is twofold. One, because there may be something there that could provide us with a possible defense, or it could impact their defense. Or two, this type of material is very important and invaluable when you're personalizing your client during the pretrial process, and it may direct you in terms of what type of secondary or supporting material that you're going to be pursuing, either through your own research online, or through disclosure through the Crown, or as well if you have to request reports or medical material, things of that nature. So you ask them about their employment in terms of what do they do, where do they work, how long they've had the position, what are the nature of their duties. Ask about their family circumstances. How long have they been married? Do they have children? How old are their children? Do the children have any health issues? Are they the main source of financial support for the family? Is there health issues with the spouse? Have there been any, you know, stressful situations on the family in recent times? Ask about their community involvement and get details of if they're involved in their community, whether they're coaching, if they participate in volunteering at their children's school. Get as much details as you can. And the reason why that's important, and I always include this in my pitch, is because community involvement, it tells you something about a person's character. And the fact that somebody is willing to take time out of their, busy life, their career, their family life to make a meaningful difference to the less fortunate in the community, I think is very telling on someone's character. And I think it can go a long way in terms of the personalization aspect that you do during the pretrial to try and get charges withdrawn. Ask some questions about their education. If they, where did they go to school, university, college, what are their diploma, degree, transcripts, if they're health issues. Health issues. This is a big one. I can't.
Hey Darren, how's it going? It's good now. I'm sorry I didn't set up our meeting last Friday like I planned. I got sick, but I'm actually working on setting us up for today.
Yes. Sorry about that. It's just it's taking away from me speaking here.
Yeah.
In terms of health issues, this is very important because again, it can provide relevant information that can go to a defense. Or again, it can also personalize the client. For example, if you're defending somebody on an impaired driving charge and you often see flushed face, well, maybe the person might have high blood pressure. So that's something that you want to canvass with them. Maybe they had problems with their walking and their balance. So you want to canvass, is there, have they had any issues in terms of with their feet, if they suffer, maybe they might suffer from gout, or if they have problems with their back, it might affect how they get up from a seated position. So, try and if they're on medication for any of their health issues, if they suffer from depression, anxiety, that's also very important. If somebody, let's say, is charged with a refusal offense, failing to provide a sample, maybe their anxiety came into play and it wasn't, a case where there was the necessary intention because of this impact of this medical issue. So, get details of if they've been to the hospital for any treatment for any medical or health ailments. Their doctors, get particulars there, have them sign all the relevant medical releases so that you're able to get the medical documentation. If you need a medical letter from a doctor, I never send a generic letter in terms of, asking for the client's medical records or, oh, please provide me a letter for so-and-so. Obviously you don't want to really disclose that the person is charged with certain charges unless your client has given you the authorization to do that. And, I try to keep the focus very narrow in terms of what I want the doctor to address in a letter. So let's say that the client does have high blood pressure. I would write in my letter to the doctor requesting a medical letter and asking the doctor, please address the following issue. Can you please confirm that Mr. Johnson suffers from high blood pressure, and what time frame has he suffered from this condition? And, what are some of the symptoms that this includes, such as, redness and flushing of the face? And is he on any medication for this? And, keep it narrow, because you don't want the doctor writing back a letter saying, well, I think my patient has a major alcohol issue and, I've spoken to him about this many times. He's never done anything about it. So that's why it's very important when you are getting a medical letter from a doctor that you send a very specific correspondence in terms of the issues that you want the doctor to address. And also that way too, they're not going on and on with irrelevant material that won't be of benefit to you, but that, they're going to bill the client for. So if there's any substance related issues, whether it's, alcohol or drug related, trying and canvass with your client. Obviously, if they've made any efforts for treatment, where they've been for treatment, you might want to get documentation. If let's say they had an alcohol issue in the past and they went to a facility, you want to get the report that confirms that they went for treatment. And, maybe they had a relapse recently because of something serious that's happened in their life. So always try and get as many details as you can when you're doing that first part of the interview in terms of their background and their circumstances. I then turn to the next part of the interview, and that is when I go through all the details of what led up to their being charged by the police. And I literally walk them through step by step in terms of what happened. Now, there's certain cases or charges where you might not want to go into that much detail in the beginning when you first meet with them. So that's obviously a decision that you have to make. So it depends on what they're charged with. Something like a DUI, you want to get as much details as you can, obviously. So the next stage, and this is all part of building, your case and at the pretrial stage, and hopefully eventually getting the charges withdrawn for your client. And obviously what's very important is disclosure. And I send a very detailed formal request for disclosure, and I make it client specific. I don't use a generic request. And the reason for that is because let's say you're asking for a video recording of your client in the cell block. We have that here in Ottawa. And you also should be requesting the video recording of when they arrive at the Sally Port of the police station or police detachment. And I know OPP has Sally Port videos. I know Ottawa Police has Sally Port videos. I don't know if other police jurisdictions do. Some jurisdictions also have in-car camera footage. And if your police service in your jurisdiction has in-car camera recording, you get that as well, because it can all be helpful. And so when you're preparing your disclosure request, you want to ask for those items. And I make it specific. So I specify the name of the client, I specify the date, because you would have that on the charging documentation. Make sure when your client comes to meet with you that they provide you with all their charging documentation, and you make a copy and give them their originals. Other things that you want to request, obviously, all the notes of the police officers that were involved. Ask for their right to counsel card. You want to see what it was that they actually read to the client in case that they didn't properly read the right to counsel to the client. So if they didn't, and they have they're all supposed to have these cards. So you want to get a copy of that. Make sure that as well, radio communications of the police officers with themselves, with dispatch, very important to request that on a DUI. Or even on a case where there might be an identification issue. You may have officers at the scene speaking to witnesses initially, then they're relaying information over the air, and that information may change later on to witness statements that are provided. And I've had that happen in the past in ID cases, and that can be very invaluable, obviously, to defending a client. Same with requesting MDT transmissions, and those are every police cruiser has a mobile data terminal. It's like a little laptop in the cruiser, and they can do CPIC queries, MTO queries on it. They can also send messages back and forth to other, to their police officers and with dispatch. And it's important because sometimes they'll be typing in comments pertaining to your client that can be helpful to your client. They may be doing queries that are contradicted by what they have in their notes. So you may have a client who gets stopped for no reason, okay? And he may say to you, yeah, I was stopped at the side of the road. I was trying to, I was checking where I was going to go on my phone or something. And then, that client may think that, maybe it was it might be a racial profiling case. Now, no officer is going to put in their notes, yes, I made a racially motivated stop, right? But, you get those MDT transmissions to see if they did a CPIC query, or get the radio communication to see if they had dispatch do a query on that person. Because, they may then, when they do the query, they'll see if your client's has outstanding charges, if your client's been charged before. They may be able to even access a photograph of your client if they're doing MTO, or if the photograph's still on file with the police. So there could be a whole bunch of material information that they're finding out that's motivating them to stop that vehicle. And if it is a racially motivated stop, that kind of information can really assist you. And, it's important because there is case law, right, in terms of it can be, even subconscious in terms of racially motivated stop. So those are helpful things to request. If CFS is involved in your case, make sure you request the working notes, the working file, the emails of the analyst or toxicologist that's involved. because that can also be very helpful. Back to police officers, request officer dashpad notes, because you may find things helpful. The dashpad notes are what they make usually more contemporaneous than their duty book notes. And there may be like relevant times that you'll see in the dashpad notes that might then be inconsistent with the notebook notes, or observations might be inconsistent with what's in the notebook notes. So that's very important to also to make sure that you have in your initial form of disclosure request. And the reason why it's important to make it case specific is, let's say it is a case that ends up being trial bound, and down the line, part of the delay is because of the disclosure. You want to be able to count on that first initial formal request that went out right away. Well, we've been asking for this material from day one. Okay. Whereas if it's a generic request, you can bet that a Crown's going to get up and say, well, we didn't get a request for the video until 3 months after. Well, no, it's right in that initial formal request. So that's very important, even just in terms of the record and an 11B application. So once you get the disclosure, I don't think I have ever in 30 years received a complete package from the Crown. There's always stuff that's missing, and there's always stuff that you can request. And I review it myself. And then I do follow-up letter requesting additional material, and obviously get the client in and review the initial disclosure with the client, get their input on it. Also, it's important that they review all of the disclosure, and you can certainly, you don't need to sit with them the whole time, but, set them up in an office to review any videotape, to review any material that you didn't review with them yourself, and have them make notes, because their notes and input is going to be very valuable to you, and, their defense, obviously. So that's very important. I never give the client the disclosure to bring home. And the reason for that is that we are bound by undertakings. You get that standard form letter from the Crown every time they give you disclosure, that you're only to use it for the purpose of representing your client on the charges, and you're not to leave your client unsupervised with the disclosure. So that's just my own standard practice. And obviously you don't want to open yourself up to any law society complaints or anything of that nature. So you've met with your client, you've reviewed the disclosure with them. What are some other steps and things that you can be doing? Well, if it's a case where, let's say, an accident is involved, it might be worth retaining a private investigator to go to the accident scene and do an assessment and a report of that accident scene that you can maybe use to your benefit, or go yourself with the private investigator to the scene. I've done that myself, and nothing beats going to the scene yourself, because then you're able to literally critically assess any reports that the police have prepared. If it's a case where social media might be important, and you can get a private investigator to do that as well and prepare a report in that regard. You might have the skills yourselves to and be savvy in that regard, and get that material. If there's information, text messages that are no longer on the person's cell phone, then you might want to get a private investigator to do a download of the client's cell phone. There might be defense witnesses that are important to be interviewed, and you want them to be interviewed early on. You can either have a private investigator do it, or you can also sit in with the private investigator when they're interviewed, and you basically run the interview, but you've got a private investigator there. And important to get those interviews recorded, just in case the witness might change their evidence down the line. You don't want to be doing it yourself, because then that could turn you into a witness. So that's why I always have a private investigator involved. If the police, more and more you see them doing interviews, and they are video or audio recording them, and I will ask from the beginning for transcripts of those interviews, but they never disclose them until literally like 2 days before the trial. So it's next to impossible to prepare for trial if you're getting transcripts 2 days before. And if you're trying to get the charges withdrawn, you're going to need those interviews transcribed, because I will watch them and I will take notes myself. And if the interview is very helpful to the client, I get it transcribed, because it's one thing for me to say, well, according to my watching of the interview, here's what this witness said. It's a lot more effective to have a transcript and then to draw the prosecutor's attention to the relevant passages in the transcript when you're preparing your ultimate presentation during the pretrial process to try and get the charges withdrawn. If there's an accident involved, sometimes the weather plays a factor. So make sure that you get the weather records. You can do that yourself by going online. The police they don't always do an accident reconstruction report unless it's something serious, but even just a simple accident, if they've laid obviously the DUI charge, there may be an accident report that's prepared. So make sure you request that in your initial disclosure request, and always request the template for the accident report. And the reason for that is that you'll see along the left and right hand side of those accident reports are all little numeric codes. Well, those numeric codes mean something. And that's why you want the template, because the template will tell you what each numeric code means and what the box means that it's inputted into. So that's also very helpful. Important to also look at the manuals for, let's say you're representing somebody on a roadside refusal. Look at the operating manual for the device, and maybe there's something there. The officer didn't follow the proper procedure in terms of ensuring that the machine was reset and ready to accept the sample when they're giving your client a few tries at providing a proper sample. And I've had many a roadside refusal withdrawn because the officer didn't follow the manual. Well, it wasn't just on my say so, it was because I included the relevant excerpt from the manual in my submissions to get the charge withdrawn. If you're dealing with the Center of Forensic Science, right on their website, they have an investigator's manual in terms of the procedures to follow for various evidence. So take a look at that. There might be, if you're dealing with a case where it's a blood sample that was taken by a hospital from a client who's charged with a DUI, or a DUI causing bodily harm or causing death, you want to try and get that manual to see if the protocol was followed in terms of the submission of the blood sample for analysis. And always request as well a copy of the submission that the Center of Forensic Science received from the police, because they're responding to that document when they're preparing their opinion. So you want to know what details did the police send in to them. So it's important to put that in your disclosure request if CFS is involved on a DUI related case or any follow-up correspondence, because you don't usually get it by the Crown unless you specifically ask for it. In terms of the gathering of information, obviously it's important to do your own legal research with respect to relevant case law that could support the arguments that you're going to be advancing on your client's behalf, and any charter issues, defenses. If you're a member of legal aid, they have very comprehensive legal aid memos on pretty well every issue that you can encounter on their site, and it's an excellent starting point for research in terms of whether it's charter related, a defense, evidentiary issue. So that's a good starting point for any lawyer. And when you're gathering your cases, and I reference cases in the package of material that I prepare, you don't need to overwhelm the Crown and or the judge with the cases, but make sure that you have, key leading cases that are very similar on point to yours, and highlight key passages in those cases just to make it easier for them. And when I first began, I touched on media exposure. If there's media coverage of your client being charged, get all those articles, because you can include that as well when you're trying to get the charge withdrawn in terms of the impact that it's had on your client. One thing that a client can readily get for you, and it's free of charge if they're on medication, and I always use this in my submissions to try and get a charge withdrawn, have them go to their pharmacy. They can get free of charge their medication prescription history, as well as medication information sheets. And it can outline why a medication is prescribed, and what symptoms it is there to address. So that can be also very helpful. Do your own online research. If you have a client who suffers from ADHD. Well, do some research on ADHD, and you'll learn that ADHD can impact decision making, or result in impulsivity. And that's something that you can also use in terms of personalizing your client and trying to get the charge withdrawn. I look at the DSM Manual 5 regarding mental disorders. It's a very, very comprehensive manual. It used to be an actual book that we had to buy, but now it's available online. And you can, if your client has mental health issues, learn about their mental health issues, because that can also be a contributing factor to what happened. And that's material that I also include in my package. And, obviously I would print it off. If it's a young person, get their school records, get report cards, get transcripts if they're in university. If they're a good student, it'll obviously help in terms of showing that they're, in other aspects of their life, they're very responsible, they do well in school. If they don't get good grades, then, it might be an illustration of an underlying issue. And, if they're on an IEP, get a copy of their IEP, get a copy of the assessment that was done. Maybe they suffer from a learning disability, and that may be helpful to you in terms of perhaps they didn't understand, when the officer was giving them instructions on how to provide a roadside sample, perhaps, or, if they've committed something like, a mischief charge and obviously didn't think through the consequences of their result. If they suffer from anxiety, and maybe that's why, they're carrying cannabis more than the legal quantity. Okay, that could be a factor as well. So always, trying to personalize the client, provide background, an explanation. If it's somebody who's got challenges in their personal life, I think that's can also be very important. When it's a young person, and I'm sure you're aware that the brain continues to develop, even into the mid-20s. And, there's a lot of research online that because the brain is not fully developed in, teenagers or young people, that, they don't have that ability to properly reason through, and, they tend to act more impulsively. So that's really important, I think, when you're dealing with, if you're representing clients that are younger. And I always try and get online material in that regard. Something else that can also be very valuable to you if you're trying to show that, the police missed a step, or, if it's a right to counsel issue and, there's problems with their notes, get a copy of the policy for that police service regarding note taking. Now, the Crown will not disclose it, but you can always get it do an FOI request to that police service, and they're required to provide it to you. Some police services take longer than others, so try and get it as soon as you can, and keep it with you. And they tend to get updated regularly. So if you have a policy from 5 years ago, chances are it's been updated since. So it's something that you might want to request every year through an FOI request to make sure that you're working with an updated policy. Look at the case law regarding the obligation on police officers to make, obviously, detail accurate notes. And the leading case is Schaefer versus Wood, and that's reported at 2013 SCC 71, and the Court of Appeal decision is 2011 ONCA 716. And there's some excellent, what I call motherhood general principles statements in that case that can be invaluable if you're trying to advance an RPG argument or a right to counsel argument in terms of the officer not making proper notes. And, you've got some excellent legal principles from that case. They're bound by their police policy to make detailed, accurate notes, and the notes are to be made before they finish their tour of duty. So if they're making late notes and they're not properly following the late entry component of the policy, well, then they're going to have a problem there as well. So get that policy, and it's important because they are bound not only by police policy, because if they don't comply with police policy, they can be charged with the disciplinary offense of insubordination or neglect of duty. But they're bound by the Police Services Act and the regulations in terms of making a proper complete record. So I want to also turn to something else that I find is invaluable when you're preparing a package to try and get charges withdrawn or getting the best possible result. Where are we at time-wise? Just want to make sure. Oh my goodness. Okay, I'm going to keep talking faster. Sorry, I just have so much to say. Letters of reference, I find, are invaluable in terms of trying to get a charge withdrawn or getting an excellent result for your client on a plea of guilty. And the reason for that is because when the Crown is reviewing the disclosure, all they see is what the police has prepared for them in terms of their investigation and leading up to the charges. They don't know anything about your client. And yes, you can certainly provide them some information, but it does not have the same impact as to letters of reference that are provided from people that know them, whether it's employers, whether it's colleagues, parents, family members, close friends. If they volunteer and they coach, whether it's from parents that know them through their volunteering in the community, they're very impactful. But it's important that the letters be in the proper context. I never say to a client, go and get me some letters of reference, because the last thing you want is a letter of reference that somebody is thinking is going to be used for a job application. That type of letter will count for next to nothing in a case, whether it's with the Crown or with the court. And my experience is that when the author of the letters acknowledges in the letter that they have been informed by the individual that they have been charged with X, Y, Z, and that they've asked to provide this letter and that they are very willing to give this letter, that counts for a lot. Because first of all, it takes a person of character, okay, to admit and to disclose to somebody that they are in trouble and have been charged. And that right there goes to their character and will count for a lot. It also adds to the value of the actual letter because the person knows the purpose for which it is being used. And that carries weight, obviously, with the court. So what I actually prepare is a memorandum for the client, and that they can use either when they speak to the person, or they can even forward it on to the person just to assist them when preparing the letters of reference. And just some key points, obviously, is for the letter of character reference or support to set out the person needs to be informed of the charges and acknowledge that they've been informed of the charges. And the letter should be, if it's going to be for court purposes, have it addressed to the presiding justice, Ontario Court of Justice. If you know the name of the judge to whom it's being addressed, the Honorable Justice, so-and-so, Ontario Court of Justice, Ottawa, Ontario, or wherever your jurisdiction may be. Suggested areas that I like to see addressed in a letter of reference or support is an identification as to who the author is, how they know the client, the relationship they have with them. So whether it's a colleague from work, a longtime friend, somebody from their church community, how long they've known the client. Are they able to provide an opinion on whether the client is someone who is committed to helping others and making a difference to others in the community? So that's important if it's somebody who's involved volunteering, or whether their work is in the helping profession. I want them to describe the client's qualities, characteristics, values, and traits as a person that they have observed, and any examples if they're able to provide of those characteristics, because that's important, because it also shows that when they're writing the letter, that the letter is obviously honest and they're giving you examples to corroborate these traits of your client. Are they able to are they able to comment on the impact that being arrested and being criminally charged has had upon your client? And that's important because, if you're talking the importance of, from a Crown perspective, well, deterrence is important. Well, if the client's been impacted in terms of the stress and anxiety, the media publicity, and that they're very remorseful and upset about their actions, it's out of character, this and that. Well, that will count for a lot just in addressing, what the specific deterrence factor that might be in the mind of the prosecutor. And if the person has any information regarding details of the client's community involvement, again, that's very important as well, and any impact that has had. If it's a younger person, I also like to get a letter from the parents. I find that that's always been valuable to me. And so again, you're asking similar questions like what we did in the other letter, but again, you want their opinion as this person's parents. How is he or she as their child? Are they respectful? Do they do chores? Are they responsible? Do they abide by your rules? Do they set an example for younger children in the house? Do they help care for siblings? Did they ever provide you with any behavioral or disciplinary issues? And whether there's any issue that they've observed as a result of COVID, which, as we know, has very significantly impacted young people and young adults. Do they normally suffer from anxiety or stress related to school or other tasks? Any learning issues or challenges that they've struggled with in school. If their son or daughter has been involved in volunteering in the community, have them address that. And and it can work both ways. Like, if they've never had an issue with the child, then that puts your client in an excellent light. And if they have had disciplinary issues, well, maybe there's an underlying condition there. Like, maybe the child needs to be, there's an issue with anxiety, or maybe there's a learning issue, and maybe that's something that the parents have been looking into or plan to look into. So it can help. It will never hurt. It can only help. Other types of secondary sources that I look at when we're dealing with health issues, the Government of Canada public health website has voluminous amounts of information regarding health conditions and symptoms associated. So, you don't even necessarily need to go the route of getting a detailed medical report. You can just go online and get information in that regard. COVID, very, very impactful these days. And, there's so much literature online about the impact of COVID, on people's mental health and on young people's mental health. And that's something I've found many reports online that I've referenced in submissions to try and get charges withdrawn. There's an excellent research paper online about the impact of COVID on young people. And it was done through the Toronto Sick Kids Hospital. And it was published in the European Child and Adolescent Psychiatry Journal. Excellent article. And it's entitled "Mostly Worse, Occasionally Better: Impact of COVID-19 Pandemic on the Mental Health of Canadian Children and Adolescents." So that's might be something that can be helpful to you. If your client has been attending for counseling, or they are going to be attending for counseling, it's important to get documentation confirming that, because sometimes, if there's an anger management issue, you might be able to get the charge withdrawn with a peace bond by showing that your client has done counseling up front. So there's no need to, put him on a court order. And get material online regarding the program. For example, let's say your client has an alcohol issue and they went through the Smart Recovery program. That program has a lot of information online about what it entails. And, I've filed that material with Crowns and judges so they can see, this is an excellent program. they can see what the program covers. So, that's something that's very helpful as well in terms of putting into context the efforts that your client has made for any issues that they've been trying to address. If you have an Indigenous client, provide excerpts from the report of the Truth and Reconciliation Commission. If their family has been through residential schools or day schools, there's so much material online in terms of the impact and the generational impact that it can have on Indigenous persons. And I've done research in that regard, and I've included that material in presentations that I make to try and get charges withdrawn. Go to the Crown Policy Manual, and everything's online now, because even if there's you approach it two ways. No reasonable prospect of conviction, and here's why. But also, even if there is a reasonable prospect of conviction, is it in the public interest to prosecute? So you want to approach both aspects to try and get the charges withdrawn. And with the impact of COVID and all the delay that's in the system, a resolution becomes very meaningful because you're alleviating the delay that's in the court systems. And that's always an important factor that judges and Crown consider. And if you go to the D38 COVID-19 recovery section of the Crown prosecution manual, there's a whole list of factors that they consider in terms of the public interest and the impact of the COVID-19 pandemic. So, the more factors that you can get to apply to your case, the stronger your argument's going to be to get the charges withdrawn. So I reference that as well in the submissions that I prepared, and I even include the relevant excerpt for them, so they have it for their reference, ease of reference. When I prepare for a counsel pretrial or a judicial pretrial, I obviously make sure I am prepared and that I have as much information as I can. So, because that's when I'm making my pitch to the, let's say we're at the counsel pretrial stage. I want to make sure I've done all my research. I have all my secondary material. I have all my letters, my reports. I have all the disclosure. So that way I've gone through it with a fine tooth comb. I've reviewed it with the client, so I know where there may be problems and issues. So when I start the counsel pretrial, and, I start off with saying, I'd like to make a proposal to you. And I indicate to them, here's my proposal and here's why. And I touch on the highlights in terms of the issues that I've identified, if it's, on the RPC side, and then on the public interest side in terms of trying to get it withdrawn. Now, obviously, the Crown isn't going to have 3 hours to listen to me. So what I indicate to them is I say, I'm just going to give you the highlights, but I'm prepared to provide you with a written submission where I will set out my resolution proposal. And as well, I will outline the legal issues. I'll review the evidence in a more fulsome fashion than what I've done in our, brief counsel pretrial, and the relevant law that's, supports my position. And, and if I have I will provide you with a separate supporting material brief. And my hardworking articling student here can attest to all the photocopies she's made on my behalf in terms of supporting material briefs. And I have never once had a Crown say to me, I don't want to review that, Connie. Okay. I've had Crown say, I don't know, I think we have a really strong case here, Connie. I don't see us withdrawing. Well, I'm successful 98% of the time. Okay. And because when you provide them with a detailed analysis of the evidence and the relevant law, and you provide them with supporting material and personalized material, chances are your likelihood of success is going to be increased tenfold. And I've had many Crowns say to me, really, you would give me material? And I'm like, well, of course, it's my job. It's my job to show you why this charge should be withdrawn. It's my job to show you why you can't prove this charge, why you can't get a conviction on this charge. Because I've had lots of clients say to me, really? Because usually defense lawyers just come in and say to us, well, you need to withdraw this charge. You can't prove it. Well, it's not the Crown's job to figure out that they can't prove it. It's your job as a defense lawyer to point out in detail to them, here's why you can't prove it. And make sure that when you are preparing your written submission and any covering correspondence, emails to the Crown, that you specifically mark it confidential and protected by resolution privilege. And that's because, let's say that, 9 times out of 10, you're successful, but that one time that you're not, you don't want any of that information being used against your client. So that's how you would guard against that. Another factor that's obviously very important in terms of these COVID times, it does take time to prepare a written submission and a supporting material brief. And, you want to maximize your chances of getting that charge withdrawn. So you're going to put in your best efforts and make it as complete and comprehensive as possible. But everybody's busy, so it's going to take you time. So I can tell you that Crowns are usually not inclined to agree to giving you that time unless there's a Section 11B waiver for that time frame. And I always tell my client, if you want me to try and get this charge withdrawn, we're going to have to waive Section 11B for this time frame. Otherwise, they're just going to want the matter to proceed to trial. And it's in your interest for me to try and get it withdrawn. So, my recommendation is we waive this time frame. And you know what? It's usually the best advice you can give them, because like I said, 99.9% of the time, you're successful, it gets withdrawn. So make sure that you do confirm that in writing with your client as well. And, very, very important that you explain to them the reason why. And I think once you give Crowns that 11B waiver, I don't think they're going to have any issues with according you the time that you need to prepare your submission and supporting material brief. In terms of resolution proposals and trying to get charges withdrawn, oftentimes you will be successful in just getting it withdrawn, but sometimes the Crowns want to see you give something. And that's where creativity comes into play. And I mean, everybody knows about the Section 810 peace bond option and, the careless driving option for DUI type cases. But there is a wealth of provincial legislation that we have at our fingertips that you can look to for a provincial offense. And, as a proposed sentence for that offense, you can look at, there's monetary penalties of a fine, but there can also be a provincial offenses probation order. And oftentimes, a Crown may be persuaded by your material and your submission to withdrawing the charges for the client being on a provincial offenses probation order. And the mandatory conditions on the Provincial Offences Act are, attend court when required. And, they're very, don't commit any other offenses contrary to federal statutes and provincial statutes. And, they're very straightforward. But you can also, there's a provision in the Provincial Offences Act for any other conditions that the court deems appropriate. So, you can always propose certain conditions there to the Crown. Let's say it's a young person and they got charged with some, federal offenses under the Cannabis Act of, having cannabis in the vehicle, which is an offense. And if they're a minor, they're not allowed to have any cannabis, period. So, try and propose a resolution under the provincial legislation, the Cannabis Control Act, and have your young person on provincial offenses probation order. Now, to be able to get to that result, you're going to want to get as much information and supporting material that you can on your client. And, if you can find problems with their case, you illustrate that too in your written submission. Other provincial legislation that I've used in the past, the Consumer Protection Act, you can use that if there's, fraud type related offenses. There's even an Apology Act. So let's say you have a client that, for whatever reason can't enter into Section 810. Maybe you can come up with, a resolution under the Apology Act and, a common law peace bond. Common law peace bond is different from a Section 810. It won't be on CPIC, so it won't have the same repercussions for somebody that might have employment concerns, and they're still bound by it because it's a court order. And you might be able, I've had Crowns accept the common law peace bond. When you're preparing the written submission, if you're addressing charter issues, I always feel that it's beneficial in terms of the structure of the written submission. I start off with what I'm proposing as a resolution. So let's say I'm proposing a careless driving charge plea to get the DUI withdrawn. So I indicate what I'm proposing in terms of careless driving, and then I'll set out the provincial offenses order of probation conditions that I'm suggesting and the monetary fine that I'm suggesting. And as well, there's under the POA, the victim surcharge is mandatory on a POA offense. And in the body of your submission, after you've have a concise statement of the issues, and then review the relevant evidence, review the relevant case law, and make it be almost an argument style. If it's not something that's going to be withdrawn, but it's something where you're trying to get the best possible sentence, I find it's very helpful to have a sentencing chart. And, in your sentencing chart, you would have the name of the case, the key facts, the aggravating factors, the mitigating factors, the sentence imposed, and any, noteworthy comments by the judge. And then, it takes a Crown or a judge, a lot less time when they're reading, instead of reading the cases, they can just go to that sentencing chart and they can see, the range of cases. And if the range is consistent with what you're proposing, it's going to go a long way in terms of you trying to get a joint submission from the Crown, or alternatively, a judge more inclined to impose the sentence that you're seeking, as opposed to, having 20 cases and reading through 20 cases, which is only going to be tedious for, everybody involved. When you're preparing your written submission, if it's charter related issues, there's some, what I call motherhood statements from some very key decisions that I always reference in my written submissions. And I'll just bring them to your attention just briefly right now. But, on the right to counsel, the superordinate importance of the right to counsel. R versus McCain, 1988, 35 CCC, 3rd edition, 481, Ontario Court of Appeal. We also have the decision of the Court of Appeal in R versus McCallan, and they talk about, again, the importance of the right to counsel. And that's at 1999, OJ number 202, and that's the Ontario Court of Appeal. And you also have the most recent decision of the Ontario Court of Appeal in R versus Rover. So I like to throw that in too. And I'll just read that little paragraph. The right to counsel is a lifeline for detained persons. Through that lifeline, detained persons obtain not only legal advice and guidance about the procedures to which they will be subjected, but also the sense that they are not entirely at the mercy of the police while detained. The psychological value of access to counsel without delay should not be underestimated. So when you have an argument of a right to counsel of choice, and your client asked, because they wanted to speak to Michael Edelson, and instead of the police officer calling Michael Edelson, they left a message on the office line at 2 o'clock in the morning, and then defaulted to duty counsel, and duty counsel spoke to your client for 1 minute. Okay, well, you've got a really strong right to counsel argument there, because the police did not do the necessary steps in implementing your client's right to counsel of choice. And if you have a right to counsel issue, I encourage, and duty counsel is the lawyer that is consulted, I encourage you to contact Sykes, which administers the duty counsel program, and you get from them the notes of the duty counsel. You request the report of the duty counsel, because it'll indicate the time of the call and how long they spent on it. You'll know what information they were given, and they even sometimes the amount of time that they have with your client is so minimal. You're just thinking like, well, how could you give them proper advice to my client if you only spoke to them for 30 seconds? So, that's important. Do a Google search of the duty counsel, because sometimes the duty counsel, they are private counsel. And I think they're always private counsel, but, they're not necessarily criminal defense lawyers. They might have, a general practice. Do a Google search for that under the Law Society for that lawyer to see if they've had disciplinary issues. You never know what you find when you do your own little investigative work. So, your right to counsel of choice argument is really strengthened if, your client spoke to a duty counsel for 30 seconds who's been disciplined by the Law Society and doesn't, has a general practice and doesn't even specialize in criminal defense work. And then, you throw. Oh,
sorry, Connie, we're at 2:02 p.m. right now. So I know Shira has to leave. So if you still have a few minutes, and if people still want to say, because it's really interesting what you're saying. So Shira, we don't want to keep you if you have to go, if you have court attendances, but if it's okay if you still have a few minutes, because it's really very interesting what you're telling us right now. So we can.
I'm waiting for an email. Turns out I can stay a little bit longer. So
okay, well, that's great.
That's great.
Yeah,
that's great. Yes, so very impactful. And those duty counsel reports and notes that you can get, you can file those if let's say your case doesn't get withdrawn and you proceed to trial. You file that under the Canada Evidence Act. It's a business records notice. You don't need to subpoena the duty counsel to come testify. So that would be helpful on a charter application down the line, just on the trial side of things. I also address section 24.2 in my written submission when there's a charter issue. You don't want to ignore that factor. And there's some, again, key motherhood statements that you can get from, R versus Grant, 2009 SCC 32 as well. The Ontario Court of Appeal, in the case of R versus Noel, 2019 ONCA 860. And this is a paragraph that I really like, when it's a breach by the police, and, the quote from Grant at paragraph 133, the police are rightly expected to know what the law is. So, unless it's some evolving area of the law, they should know by now how to implement, a right to counsel of choice for a person that they have in their detention and custody. And from Noel, the Court of Appeal recently noted, the law around Section 10B is clear and long settled. It is not difficult for the police to understand their obligations and carry them out. I always include that in my written submissions, just to kind of, take away, well, the police were acting in good faith. Well, you're not going to do well on a 24/2 analysis, and, throw in those motherhood statements. And, there's lots of compelling statements from, the lower courts, both SCJ and OCJ. But, when you're doing a written submission, I think just, some key OCA and SCC passages can be very impactful for you. So I know we're now over time. I did have more to talk about. If Shira wants to jump in with some questions, we can certainly pause me talking on, and I can certainly take some questions. Shira, did you want to jump in? I know we had a list here. I tried to cover everything that you had wanted me to cover.
And I'm just looking because you've covered everything that we've discussed and more. I'm just going.
Oh, no, I think number 7.
Oh,
ask that one.
That was a good one. That was a good one. Yes. So how do you handle demanding clients during the pretrial stage?
And Shira and I talked about this the other night, and I addressed it earlier, and I think it's really important to keep clients informed, keep them always updated. I mean, this is about them, okay? And, you keep them informed, speak to them on the phone, send them email updates regularly, and I think that that'll go a long way to easing their anxiety. Obviously, if it's a privately retained client, you have to explain to them, you're on the clock here, and I will always answer your questions. I'm always here for you. But if you keep asking me the same question 10 times, you're still going to be billed for the same answer. So I'll set it out in writing for you, and that way you'll have the information there at your fingertips when you need it. So I find that goes a long way in terms of easing a client's anxiety and just keeping them informed in terms of every stage of the process. One thing that I do like to do, though, is when, let's say you are resolving the case and the charges are going to be getting withdrawn, and you're resolving it with a provincial offense, you still need instructions from the client for that resolution, and you want to make sure that the client is informed and is aware of what are all the consequences of their plea of guilty. I send a very detailed information package to clients, especially when it's you're dealing with the impaired context, and whether it's a plea of guilty to the criminal charge or whether it's to the a careless driving charge. And if they're on an ignition interlock condition, whether it's by way of a provincial offenses probation order, or if it's MTO, ordered, it's obviously it's a condition of their license. And that condition of their license, whether they were stream A or stream B, doesn't just end when the stream B or stream A time period has ended. They have to actually put in an application to MTO to have that condition removed. And that is something that, I make sure that I include in my reporting letter to them. And it's usually a very detailed package. And the ministry normally is required to send that form to the person to remove that condition about 15 days before. But, you know, they can also complete the form at any Service Ontario location. So if they don't submit the form, the condition remains on the license, which means, you know, they may think, oh, once my Stream B time of, you know, 12 months is done, I can drive my dad's car without the device. No, no, no. You got to get that condition removed from the license. So very important that you put that in your, you know, your letter that you're sending to your client. I do, like I said, a very detailed letter, just setting that all out in terms of the consequences. Make sure that they know that it could impact their insurance. The fact that even if the charge gets withdrawn, the fact that there was an ADLS, that automatic 90-day suspension, that could impact their insurance. So I always tell clients, don't be shopping around for a new insurer. You know, just let them send you the bill and you pay it. You know, don't remove the insurance off the vehicle for that 90 days, because when you go to get the reinsurance, when you go to get the insurance reinstated, they're going to run your driving record. Or if you're shopping around for a better rate, they're going to run your driving record. They're going to see that ADLS and they're going to charge you with a higher premium. So I always, you know, tell clients that, and I put that in my my reporting correspondence to them. I explain in my correspondence the way that the actual ignition interlock device works, and you can get that information online. And you know, what can cause a you know, a failure of that device. And you know, if you tamper with the device, that can cause, that's a violation. If you know, the you have any alcohol in you, it has, if it's over 0.02, it will, that will obviously notify MTO. It shuts down the vehicle, and it's considered a violation. If you miss an appointment with the ignition interlock service provider, that's considered a violation. So, you know, I set out in my reporting correspondence, you know, all the things that can be seen as violations, because, you know, if they violate this program, well, they can be, you know, kicked out of the program, or their license can be taken away and they can't drive for the balance of the program, you know. So, I mean, that's important that they know that. And, you know, to be eligible for the program, I make sure that they know, you know, that they can't have any outstanding fines. So they have to pay any outstanding tickets. They have to pay the fine that's imposed by the court, whether it's on the careless or the, you know, the criminal charge. You know, you have to be registered for the Back on Track program. And people don't necessarily know, but you have to complete that entire Back on Track program within 12 months. And if you don't complete it within 12 months, your driver's license is not properly reinstated. And don't expect that you can get in just because you want to get in, because they tend to be backlogged. So you want to get in right away to make get the assessment done. Then they do the referral to whether it's the treatment program or the education program, and they have to, you know, comply with that. And then they have to do the exit meeting with the provider. And, you know, it's very important that, you know, they complete it within the time frame. So make sure that they follow the time limits with that. And, you know, don't wait till 9 months down the line to try and make an appointment for something.
Connie, I do have a question though, about what you were saying, how you provide like a kind of a detailed memo to the Crown to try to get the case, the charges withdrawn. Thing though that I wanted to ask you is, do you write this memo after you get some kind of assurance from the Crown that they are willing to seriously consider resolving the case? Because the danger here is if you point out all the weaknesses to the Crown and then they say, well, sorry, we still think we have a strong case, and they want to take it to trial, like, isn't there a risk of you kind of disclosing in a way or telling them what?
Well, fortunately, I've never had that happen. I've always been able to successfully persuade them. But you know, they have to have an open mind. And that's what I asked for in the council pretrial. I asked the Crown, you know, all I ask of you is to have an open mind. And then, you know, I don't go to the time and trouble of preparing it in advance. I just have my talking points, and I know my file, so I can go through everything in the pretrial. We used to do them in person. Now we do them on the phone. But you know, if the Crown says, Connie, I'll keep an open mind, then I would just, you know, confidential, protected by resolution privilege. And that's how I mark all the documents. Now, if you have a Crown, then the Crown says, Connie, I've reviewed everything, but I don't know, I still think it could go either way. Then I say, you know what? I say, why don't we do a judicial pretrial, and we'll get the benefit of the presiding just the judicial pretrial. So then you make sure that you send your written submission, your supporting material brief in advance to the JPT judge. And when the judge sees that material, and then you're in your pretrial and the judge has had the benefit of this or reviewing this material, we are in such a backlog system now. What judge is not going to indicate to the Crown, I've read Ms. D'Angelo's submissions, you know, they're very thorough, and I think she's bang on. I think you should give serious consideration to withdrawing these charges. And I think that's, so if you've got a Crown who's kind of on the fence or whatever, set it for a JPT, because, you know, I think it's next to impossible to do, you know, a DUI in like, you know, less than a day. And I think just for a time estimate purposes, they probably want a JPT in any event and get it before a judge. And you know, I think, you know, a compelling argument will be very persuasive. And if you're not successful with the Crown, I think getting a judicial endorsement of what you're advancing will, you know, maximize your chances of getting it withdrawn. Especially nowadays, they are so backlogged in the courts.
Yeah.
We have a few questions that we've received. I received some messages through the chat as direct messages. The first question is, what are your thoughts on trying to resolve a matter before the first appearance?
I have never done that. It's pretty well impossible to do that because I've never had disclosure before the first appearance. Usually we get the initial disclosure after the first appearance, and in 30 years of practice, never have I received complete disclosure. I'm always having to write for something. And it's so important to have full and complete disclosure, because then you can take their case apart. And that's how you find all the problems with their case, to try and demonstrate to them you have no reasonable prospect of conviction here. Now, I like to organize my files, my cases, in a way that it's very easy to work with when you are preparing these submissions. And my student, Ms. Bégin here, is nodding her head. And I do this with simple files and files that are, you know, 20 bankers boxes. And what I do is I use file folders like this. And I have a file folder for each witness. I have a file folder for each police officer. I have a file folder for my charging information. I have a file folder for my release documentation. And in this file folder for every witness, I include the witness's statement. If the witness made a 911 call, the transcript of that 911 call goes in that file folder. If an officer has a note in his notebook about a statement that witness made, that photocopy of that officer's note goes in that file folder for that witness. So everything that pertains to that witness goes in that file folder. So when I am reviewing the evidence and I'm preparing my submission, and this is obviously is true too if you're preparing for trial and you're preparing the cross-examination of a witness, everything that you need for that witness is all there. And you're not scrambling, oh, I remember I saw something somewhere. I know some lawyers like to use binders. I don't like binders because I find them too cumbersome to work with. And if you're working from home, you can easily bring file folders home as opposed to carrying heavy binders. If you're tech savvy, and I'm very old school, I know you can do the folder organization technologically, like in terms of have it done electronically in folders electronically. I'm a paper person, but that's just because I'm old, right? But you know, obviously for younger lawyers, you know, you can do the same thing technologically. But I find that works efficiently and effectively for me.
And another question that we have is, how can we obtain the Sykes Duty Council report? And also, how do we spell the Sykes report?
SYKES, and they have a fax number. It's Sykes Assistant Services. I don't know the fax number off the top of my head. My student can get it for us quickly. I didn't make a note of it. Sorry about that. But you can also get a copy. I'm pretty sure you can get a copy of the recording of the call from the police officer. but they only keep them, I think, for like 30 days or like a very short time frame. So it's you might want to get the recording right away, just from meeting with your client, because you'll have the documentation that the client has from when he was released. It includes the ADLS will have the date and time of the offense and the name of the officer who arrested him. So when you're writing to Sykes, you have to send them. You also have to send a authorization from your client, authorizing them to release that material to you in terms of the duty council notes and reports and any recording. So you'd have to have your client sign that, but you have to list the charges, list the offense date, list the charging police service, list the name of the police officer. If you can approximate, if you have the disclosure already, you'll know the time of the call, which will probably assist them. If you don't have the disclosure as of yet, the time that the client was arrested, so you can give that, the arrest time was 10 o'clock at night, so the call would have been later, type of thing. And sometimes it's important to have that recording. Maybe the officer didn't give proper information to the lawyer. I mean, you never know. I mean, I always say it's the more you dig, you're often able to find, material that can assist you in your defense of your client. But oh, okay. So did you find their fax number?
And their email as well.
Okay. Yeah. And I think if your client is on legal aid, they do not charge you for it. If it's a privately retained client, I think it's a nominal amount, like something like $50 or something. It's not an outrageous amount. And I always get it every time that there's a right to counsel issue. If they've spoken to duty counsel and there's a right to counsel issue, I always get that material, and it's proven invaluable.
The next question we have is, how can counsel get records from a client's school regarding the school's own investigation of allegations, for example, bringing a weapon to the school? And is the counsel entitled to student witness interview notes, school surveillance footage, and other disclosure at the school?
That's interesting. I remember I had something similar years ago, and in terms of like, if it's something like that, you could try an FOI request. You could try that through the school board. See also if the parents could be able to get that. I know material like IEPs and assessments, the parents can get from the school. Because I've been able to get that type of information from the parents. But if there is an investigation related to the school, try doing an FOI through the with the school board and see if you can get it that way, or maybe through even the Ministry of Education, because the Ministry of Education, is I guess the provincial body that oversees the school board. So you can always try an FOI request to the Ministry of Education, and they may redirect you to the school board as well. You could try both avenues and see.
The next question we have, is there a page limit that you use for your submissions to the Crown for resolution?
No, I don't. And some tend to be very lengthy. And I just, try to be as comprehensive as possible. And I think I'm safe to say that I'm renowned for my thoroughness. And I always apologize ahead of time to the Crown. I say, that I like to be thorough. But I've never had a Crown be negative about, or resent the length of the submission. They've always been very appreciative and very thankful of it.
Thank you. And everyone in Ottawa knows that you're renowned for your thoroughness.
Yeah, thank you for that.
The next question, this is the last question that we have here, is the call between duty counsel and the client also recorded, or just the call between the officer and duty counsel?
My understanding is that they record just the call with the officer. When the officer calls in and provides those preliminary details, I believe that's what's recorded. That's what I've requested in the past. But you never know. Maybe they'll start recording them, or they have been recently recording them. And if you can get a recording of it, even better. But I don't know if I haven't requested anything like that.
Isn't there some sort of client privilege though over?
Yeah, but he's your client, right? He'd be waiving the privilege. The privilege
Okay.
belongs to the client, not to the duty
If he
counsel.
gives you permission, right?
Well, of course they will,
yeah.
right? Yeah. Yeah. I mean, if there's a competency issue, you know, in terms of the nature of the advice that was offered, you know, try and see, put it in your request, see if they have it. I don't think that they do, because the way the call works, it goes through like a call center. And I think, and then I think the calls are, the duty counsel is then calls the police. Like the police don't call and get a duty counsel right away on the phone. It's like a call center, and this information is provided. I think it's even like automated. And then the duty counsel, they're obviously working from home, and then get assigned this call and then call the relevant police station and obviously provide the advice type of thing.
Right. I think that's it, right, Shira? Do you have any more questions?
No, I think that those are all the questions that I've received through the chat.
Yeah, I don't see any other questions, but thank you so much. Oh, there is.
There's one
So
last
do you,
question.
right. Yeah, go ahead, Shira.
Wrote, which is, do you keep your materials in folders for trial as well, or do you put them in binders?
I don't like binders. I always use folders. I find it so much easier if you're cross-examining and everything is one place and it's in folders. I don't like binders because they're cumbersome. We've had major cases with binders and the binders exploded on us in the courtroom, and you're frantically trying to assemble it. So no, I do not like binders. I like folders. I just find it's just so easy to have everything at your fingertips. And if you're trying to find something, you know, let's say an issue comes up, like especially if it's in a big complex case, you know, and when you're talking like bankers boxes of material, and you know, you got to have information at your fingertips. And I just find it so much easier to have things in file folders than to have things in binders to try and get those documents.
All right. Thank you so much, both of you, Connie and Shira, for your time, and Connie for this excellent presentation. There was a lot of information that I'm sure everybody will find very useful.
I hope it was helpful, people.
I'm sure it is. I thought it was very helpful, and maybe that will help us resolve a lot of cases before we even get to trial. So thank you so much. And this is this CPD qualifies for 1 hour of substantive CPD hour. So
do I get to claim the hour too?
Yes. Thank you so much. So we'll see you next time for the second part, which will be with Sid Friedman, and we will be talking about the trial stage. Thank you very much, everyone.
Thank you, everybody, for your time and listening to me today. I hope I was able to be of some help to you today.
Thank you, Connie. It was incredibly helpful. A lot of good information.
Yeah.
Thank you.
I agree.
Thank you. This was so helpful. And I know I'm going to be looking up the Apology Act. Never heard of that one.
You'd be amazed at what's in those provincial statutes.
Thank you again. This was extremely helpful.
Oh, you're very welcome. Thank you for the kind words.
I agree. All right. Thank you very much, everyone.
Thanks, everybody. Have a great long weekend.
Okay.